Camillus Galvan.
Okay.
I'm sorry.
No, that's all
Oh,
right.
no, I call it files in order of appearance. I haven't received his file, so you're fine. Yes.
Apologies, Your Honor.
All right, who's this in behind?
That's my second client, Your Honor, who was called right after Mr. Randall. They're unrelated, other than that.
Oh, just have a seat. Okay. All right, who is this?
This is Matthew Rendon, Your Honor.
Okay.
If I may,
Yes.
this case has a companion case set today as well. Mr. Bloomquist is on the senior case. And our understanding after conferring with state is that the senior case is to go first. I understand that you're gonna do no revision
Yes.
order. But otherwise, we're ready, Your Honor.
All right. Thank you.
And I understand that the court sets the order.
Okay. Oh, no. No. It's fine. All right. See you back at 1:30.
Understood.
All right, Camillus Galvan. All right, and he's scheduled for jury trial.
Yes, Your Honor.
All right, 1:30.
Understood.
Thank you.
We come back. I'm there. May I take
That's
this for now?
Yes. All right, Neely,
We confer, Judge.
and on Mr. Neely, were you all able to come to an agreement? All right. So then those are the documents the court needs. And this is going to be the last setting for restitution. If I don't have those documents, then it's going to be $0 restitution. Because this has been set for, oh, where's your client if he can come up? All right. So we're back on the record in 2024 CR 3316 State versus Ezekiel Neely. So this is going to be the last time that I set this for restitution hearing. And this is the reason why. We were here on October 17th, 2024 for restitution hearing. We came back on October 31st for restitution hearing. We came back on November 21st for restitution hearing. We came back on December 3rd for restitution hearing. And now we're back again for restitution hearing, and I still do not have documents in order to make a decision on the restitution amount. So this is going to be the last day for restitution hearing. If I don't have the documents, I don't have the documents. This is going to be set, and I will give you all an option. It can be reset for January 23rd or January 30th.
Judge, to make sure I understand the court, so this is the last one, but we're having a final one or?
Oh, no, this is it.
Okay,
If I don't have the documents by that date, the restitution amount that's going to be approved for Mr. Cervantes is going to be $0. And
Sorry.
people can handle it on this in the civil court. So January 23rd or January 30th?
January 23rd, Your Honor.
Are you good with January 23rd, State?
I am.
Okay, all right. January 23rd, final restitution hearing.
It's a deadline to submit the documents the court needs, correct?
Yes.
Thank you, Judge.
All right, thank you. Once you sign the reset form, you're excused. All right, you ready?
I'm here, Judge, yes. I apologize.
Oh, that's okay. Armando Garcia. And is there an application in this case?
There's not, Your Honor.
All right, probation, no application. All right, Deputy, could you move them down to the other end? Court is calling 2024 CR 008210, State of Texas versus Armando Garcia. Can I have parties announced for the record for the state? Defense?
Michael DeLeon for Mr. Garcia.
And are you Mr. Armando Garcia?
Yes, Your Honor.
Counsel, have you received all discovery?
I have, Your Honor.
Did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Garcia, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do waive reading, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor. We're waiving count 1, waiving count 2, waiving count 4, and the repeater. And proceeding on count 3 alone.
Any objection?
No objection, Your Honor.
All right, did you review the court admonishments and waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with assault on a peace officer as a second-degree felony? Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
According to the plea, state is proceeding on count 3. Punishment is to be assessed at 2 years in the prison. There are no applications, and this is the run concurrent with cause number 2022 CR 5698. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea? Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Just that we'd ask the court to follow the agreement of 2 years TDC. He has been revoked on his MTR previously for 2 years. Those running together. Plus, he's got about since May of 2024, so about approximately 7 months of jail credit, which we're asking the court to, of course, give him.
All right. Court will follow your agreement, find you guilty, sentence you to 2 years in the prison, give you credit for any time served. This will run concurrent with 2022 CR 5698. All right, good luck to you. Thank you, Your Honor. Could you do me a favor? Could you call Alfonso Cabanas back, please?
You be back at 1:30, or do you want me just to wait here?
1:30.
Okay, thank you.
You're welcome. There, he has someone else on the docket.
Yeah.
State on Henson, the cause number 2024 CR 010449. What is happening with that case? Yes. All right, thank you.
We'll waive his presence, Judge.
All right, so if y'all put that on the record that you're waiving his presence. All righty, let me find it. And are you ready to proceed?
Sort of, defense did file a request, I did respond to that request, I'm sure there's a copy of it, I do have a copy. If you'd like.
Yes.
And then today I was handed an affidavit that I reviewed, my response doesn't address the affidavit, so I guess I can just.
Okay, where's the affidavit? Because I don't have it.
I gave a copy to the court. That should be with the court's file.
It's essentially.
All right, so this deputy will need to be called.
That was gonna be my argument.
All right. And then I need to know which juror was that? Was that a alternate? Who is it?
That's why we're trying to get the juror card so we can investigate that. So
Well, no, I mean, she should be able to tell us who it is.
And I think the whole basis of the motion is there needs to be good cause.
Yes.
And so far in the motion, the defense has filed, and even in this affidavit, which is hearsay, I don't think there is enough. There are any good cause.
Okay.
And Judge, again, so today's day 30, so that's why we're here trying to get the juror cards. I'm not trying to ask the court or the prosecutor.
Oh, no, there needs to be evidence submitted to the court in order for the court to give juror cards.
Right.
And this, what you're giving to me, this affidavit, it's all hearsay. So.
Any affidavit's gonna be hearsay, even the bailiff getting
Yeah,
information from a.
Well,
juror
what I'm
is
telling you
hearsay.
is it's hearsay. So
All
what
of
I
it's
need
gonna be
is
hearsay.
that witness,
That's why
whatever
we
you
need the
have needs to
juror.
come in. No,
The
the juror
only-
doesn't need to come in. Whoever is making this affidavit needs to come in.
Thomas Lang?
What
No,
is-
the person he obtained the information from.
They're obtaining, and it's all obtaining information from someone else. We need the source, which is the juror.
No, the source is the bailiff who your witness, Thomas Lane, is saying they obtained this statement from a deputy who's not the deputy in the 187. So that deputy needs to be here.
So the court is ruling that this affidavit that a bailiff is
Yes.
saying that they didn't take it is not good cause.
No, it's not. You'll need the the deputy here.
Okay, so again, today's day 30, so I guess I can try to get him here, or I'll file the motion for new trial, and then if the court grants a hearing, I can issue subpoenas at that time.
However you all want to do your case is completely up to you all.
Well, there's no real hearing date because it's just trying to get juror cards. So I don't know if I really am able to subpoena somebody for that
Right.
based on that. So that's why we attempted to get an affidavit from someone else who's an officer of the court. So, but I guess I don't know. It's for good cause. We're trying to make sure that the judicial system worked properly, that everything was followed properly. So I'm not sure.
No, the court determines whether or not it's good cause. And to go into documents to have the court release jurors' information based upon hearsay is not enough. So what you need is whoever this person is that Lane obtained information from, then that person needs to come in and testify. The court is not going to release all 14 jurors' information based upon this deputy saying that they spoke to a juror or one juror spoke to them. That doesn't mean you get every single juror's information, and that's what you're asking for.
And we would need to ask each juror, did that juror tell you?
No,
Did
you
they-
need to
did they
ask.
ask specifically?
No, you would need the deputy, because according to that affidavit,
The
it's
deputy
saying
still
that,
wouldn't know. I'm sorry, I'm
you know,
interrupting.
so here's the thing. That deputy who's alleged to have told Thomas Lane something, then they need to come in and testify and say, yes, this is what I said, and this is the specific juror I spoke to. What I am telling you is I am not going to release 14 jurors' information based upon a hearsay statement from Lane. You would need to have that deputy to come in and say, this is the juror I spoke to, or who spoke to me.
We would still request all the juror information, asking if that juror relayed any of that information to them.
And what I'm telling you is I'm not going to release the information to anyone, state or the defense, of 14 jurors when, according to the affidavit that is here, the deputy is saying it was one juror. That's what I'm telling you.
So we can't even get their names,
No,
even though the court puts their names on YouTube and leaves it
No.
out there.
and I did not put their names on YouTube. So let's be honest and truthful. I do not put the names or the faces of any jurors on YouTube. I know people like to say things, but that is not true. So here's my suggestion, and I'm not telling anybody how to run their case, but it appears that people keep asking me for things that I'm not giving them. So I want to be very clear. I am not giving the state or the defense 14 jurors' names, addresses, and information based upon a hearsay statement. What I suggest you all do is, if this deputy is saying that something happened, and that is not a deputy that's in this court, I would suggest you get that deputy in here to say, specifically, this is the juror I spoke to. Now, according to your affidavit, if everybody's taking that affidavit as true, she is saying it's one juror. There is no way I'm giving people 14 jurors' name when it's alleged to be one juror. The end. Is there anything else? All right, thank you. All right, thank you. All right, is there a reason Christopher Gonzalez isn't dressed? Christopher Lee Gonzalez, is that what he's wearing for trial today? Why isn't he dressed? Counsel, is there a reason he doesn't have any clothes? Yes, I mean, does he want to go to trial in orange? Sure. Good afternoon. So you're scheduled for jury trial today, but obviously it wouldn't be fair for you to go to trial dressed in orange. So your attorney is going to get clothing for you He says this evening, and we're going to bring you back for jury trial tomorrow. You understand? So it will be going to trial. Your plea deadline date has expired. The court will not accept any plea bargain agreements after today without good cause. Otherwise, you would have to plea open to the court. Do you understand? Yes. So with that being said, unless you all have reached agreement, you're going back to custody
Okay.
for jury trial. You're welcome. All right, he's coming back tomorrow. Ricardo Garcia. All right, you're up for jury trial.
Your Honor, I'm not ready for, to continue. I put a motion to dismiss and affect this counsel. And I think I have brought it up the last time I came, of the court, that I wasn't aware that I was indicted, and I was handed an indictment, but that day, and the last time that I came out, I feel like I wasn't given sufficient time to prepare, to any objection to the indictment. I wanted to go over the indictment and look over it.
All right, you can go back in the box and look over the indictment with your attorney, but let me explain something to you. Your attorney went to law school. If your attorney feels as though there's nothing wrong with the indictment, then they're not going to file any motions
I understand.
in
I
regards to
understand
that.
that I didn't go to law school, but
No, I'm just saying
Yeah.
that this is an attorney.
yeah,
If they've gone over the indictment with you and they say there's not an issue with the indictment,
I understand.
then they're not going to file any motions.
Well,
as it
he
relates to
hasn't
the
gone over the indictment with me. And
All
then,
right, sit over in the box. He'll go over the indictment with you. All right.
so I can't, I don't have no confidence in.
All right. So what you can do is you can sit in the box with your attorney. Your attorney will go over the indictment with you.
Okay.
Thank you.
Judge, there's also the mental health issue that I mentioned earlier. I've learned that he's not taking his medication, he's hearing voice.
Okay.
And so I'd like to file a motion for mental health eval.
All right. Who's the prosecutor on Ricardo Garcia? Defense counsel is requesting a competency evaluation. So,
Sorry to interrupt you. I conferred with defense counsel earlier and I have no objection to his motion.
all right. So he's going to go back. The court is legally bound to give a competency evaluation when it's requested. So recall this back and we'll put it for jury trial. We'll put it for January 27th and see if the competency evaluation is completed. If it is, that's the date for your jury trial date.
Thank you, Judge.
All right, thank you.
May I be excused?
You want to tell your client?
Yes, Judge, I would.
Sorry.
Right.
Ricardo, aka Richard, Garcia Jr., age 47. 2024 evading arrest detention with vehicle. 2024 unauthorized use of vehicle. Bond $15,000 offense, and arrest date the 23rd of April, 2024. KCC 732739. 2024 duty on striking unattended vehicle bond $1,000 offense, and arrest date. The 23rd of April, 2024. Case NM 761886. 2024 evading arrest a detention with vehicle rejected, multi-count. KCR 2024-021A. 2021 Comal County Possession Controlled Substance Penalty Group 1, 1B less than 1 gram case, is still pending in Comal. Booked, the 10th of June, 2021 1 day released on $5,000 bond. Rearrested for failure to appear in Comal, and on warrants from Bexa the 11th of January, 2024 6 days $15,000 bond. Case DC 2019 CR 11404. 2019 evade arrest a detention 2 NDOR sentence 2 years probation extended probation supervision terminated unsatisfactory 7 MTIs. Looks like no further punishment. Case NM 416117. 2018 driving while intoxicated with a little one under 15 dismissed, other. Case DC 2017 CR 4063. 2016 burglary vehicle third OR Moore sentenced 2 years, 247 days credit, def release TDCJ the 11th of June, 2018. Case DC 2017 CR 4064. 2016 credit, a debit card abuse dismissed, defendant convicted other. Case DC 2013 CR 9858. 2013 theft firearm dismissed, defendant convicted other. Case DC 2013 CR 0980. 2012 burglary vehicle third OR Moore sentenced 4 years, 272 days credit M, def release TDCJ the 17th of May, 2016. Case DC 2013 CR 0981. 2012 burglary vehicle third OR Moore sentenced 4 years concurrent, 272 days credit, def release TDCJ the 17th of May, 2016. Case DC 2013 CR 0603. 2012 evading arrest or detention with vehicle sentenced 4 years concurrent, 271 days credit, def release TDCJ the 17th of May, 2016. Case DC 2012 CR 2302. 2012 felon possession firearm dismissed, defendant convicted other. Case DC 2012 CR 1534. 2011 possession controlled substance penalty group 1 less than 1 gram dismissed, defendant convicted other. Case DC 2012 CR 1102. 2011 burglary vehicle third OR Moore sentenced 4 years concurrent, 271 days credit, def release TDCJ the 17th of May, 2016. Case NM 123794. 2011 theft $1,500 TO $20,000 vehicle rejected, extraneous offense. Case DC 2009 CR 9782A. 2009 burglary vehicle third OR Moore sentenced 22 months, concurrent, 310 days credit. Case DC 2009 CR 9783A. 2009 burglary vehicle third OR Moore sentenced 22 months, concurrent, 310 days credit. Case CC 295667. 2009 theft $50 to $500 dismissed, defendant convicted other. Case DC 2009 CR 9780. 2008 burglary vehicle third OR Moore sentenced 22 months, concurrent, 310 days credit. Case DC 2009 CR 9781. 2008 theft $1,500 TO $20,000 sentenced 22 months, concurrent, 310 days credit. Case CC 274905. 2008 burglary vehicle dismissed, defendant convicted other. Case CC 295666. 2008 criminal mischief $50 to $500 dismissed, defendant convicted other. Case CC 282955. 2008 burglary vehicle second dismissed, defendant convicted other. Case CC 282956. 2008 burglary vehicle second dismissed, defendant convicted other. Case CC 282957. 2008 burglary vehicle second dismissed, defendant convicted other. Case CC 283002. 2008 attempted burglary vehicle dismissed. Defendant convicted other.
Case CC 283003. 2008 burglary vehicle second dismissed, defendant convicted other. Case CC 283007. 2008 burglary vehicle second dismissed, defendant convicted other. Case CC 283011. 2008 burglary vehicle second dismissed, defendant convicted other. Case CC 275257. 2008 burglary vehicle dismissed, defendant convicted other. Case CR 833999. 2002 driving while license suspended, sentenced 80 days, 41 credit, sentence expired early. Case NM 715118. 2002 burglary habitation, force dismissed, insufficient evidence. Case DC 2001 CR 5643. 2001 possession controlled substance penalty group 1 is equal to 1 gram 24 gram, sentence 5 years deferred, probation revoked after 5 MTRs, resentence 5 years, with 209 days credit, concurrent with prior sentence. Defendant released TDCJ March 10, 2005. KCR 712006. 1998 burglary vehicle, sentenced 1 year probation, probation revoked, resentenced to 48 days, only served the 24 days credit on this one. CR 637206. 1996 burglary vehicle, sentenced 1 year probation. NM 511318. 1995 credit/debit card abuse dismissed,
I just
insufficient
wanna say for the record,
evidence.
I understood what you just told me, and we had the opportunity to go over the indictment when I last came to court, when I found out I was indicted, and I was ushered out, and he explained to me that he was gonna come visit me. I've been incarcerated for 10 months already, and I have not had one visit from this man or had any written correspondence from him. He's given me 2 different numbers that I haven't been able to get a hold of. He told me he was gonna be out of town the last time that we talked for the holidays. So that's the reason why I figured he didn't answer the phone now. You asked him to go down and sit down with me over this indictment, and he pulled up that mental health issue without coming to me and asking me, hey, you know what, I'm gonna ask for this motion to go in. Motion that I would have wanted to him to put in, we haven't discussed or gone over this indictment, and I've been indicted since August 15th. I wasn't known, this wasn't brought up to me till October. And he still hasn't gone over this indictment with me or discovery, so,
All right, so here's the
Okay.
thing. I'm gonna take this process with you step by step.
okay,
If there's something that I tell you that you don't understand, just let me know. Okay? So this is based upon my experience
yes, ma'am.
as a defense attorney.
Okay,
Sometimes, as a defense attorney, you don't know when your client has been indicted. And let me just tell you why. The reason why you don't know is because you're not his only client.
Yeah.
Sometimes you have attorneys who have 12 and 15 clients, sometimes more. So they don't go on your case and they don't look up every single day to see if you're been indicted.
Okay.
So sometimes what ends up happening is how they know you've been indicted is they receive a letter in the mail or card in the mail saying this case is set for today,
okay,
which means that the case has been indicted.
okay,
The prosecutor, they don't pick up the phone and call
Yeah.
your attorney and say, hey, just so you know, I'm taking your client's case to the grand jury tomorrow.
okay,
And then if the grand jury says, yes, there's enough evidence to hold them over for trial and we're going to indict it, the prosecutor normally doesn't pick up the phone and call every attorney that's on that list and say, hey, just to let you know, the grand jury indicted your client today. So sometimes the first time that a defense attorney will know, and this is not saying anything bad about the defense attorney, this is just the way it works. Sometimes they don't know that you've been indicted until they get a notice telling them they need to be in court because your court is set that day. And let me just tell you, with indicted cases, I won't know you've been indicted until it gets set on the docket.
Okay.
And I don't set it on the docket. It's done automatically through the computer system. So that's why he can't come to you and say, oh, by the way, you've been indicted. He knows you've been indicted when he's ordered to be in court. So he's here today, right? Now, the next step in the process in this court, I make sure everybody has all their discovery, and then I require the state to tender an offer. Once the state tenders an offer, then your attorney will let you know what the offer is. You can either accept it or reject it. I'm here all day. So if you don't want to accept it, that is fine. Then you'll be scheduled for a jury trial. So today is your jury trial date. Now, what holds up a jury trial? Sometimes maybe there's some new discovery that's been given. I don't have the defense attorney's requests continuances normally for that because it's not really their fault.
No.
Now, if your attorney thinks that there are some mental health issues, what do I mean by mental health issues? They feel as though you don't understand what you're charged with, the consequences of the decisions you're making related to that charge, or if they see that maybe at the jail, it says that you've been on mental health medication, they may say, maybe this person isn't competent. And once an attorney legally comes to the court and says, I believe this person needs to be evaluated to see if they're competent to stand trial, then that stops everything. And then what I have to do legally is I have to send notices out, send an order out saying, I want this person evaluated for competency. Because it wouldn't be fair for an attorney to go to trial with the client and that client doesn't know the consequences of the decision he's making. And as someone who's accused of a crime, you have certain rights. You can make a decision on whether you want to testify or not. That's not your attorney's decision. Your attorney may advise you, but that's your decision. You can make a decision on whether you want to enter into a plea agreement or not. You can make a decision on whether or not you want to waive jury trial, but the waiver of the jury trial, the state has to agree to it as well. So your attorney has stated to the court that he believes there may be some competency issues here. So with that being said, legally, I must, and I will have a doctor come see you to evaluate you. And then we're going to come back, and we're coming back on January 27th. Because that's the length of time it's taking to get evaluations done. I don't know if your evaluation will be completed by that time or not, but we will see.
Okay, I partially understand everything that you explained.
All right,
to me.
what
I
do you
wanna
not
say
understand?
Thank you.
Let me know.
What I don't understand is if I have certain rights, the way you expressed, and his obligation to go over those indictments with me when he gets notice of it. Okay, so this is the second time that I've seen him. Now it's been 10 months. We could have that's more than enough time, I feel. And 30, 45, 40 days since he got the indictment should be sufficient. He still hasn't gone through it with me.
Okay.
We've been sitting
Well,
there.
I tell you
So
what,
that's basically why I'm bringing up my loss of confidence in him and why I submitted the dismissal
Mr. Hardy.
in case I do lose in trial.
All right, Mr. Hardy, will you go over the indictment with him? I know that you've already said that you want a competency evaluation done, which will be done. But,
I'd be happy to address.
all right, so he's going to go over the indictment with you today. Listen to him, okay?
I will.
And then we're going to bring you back on January 27th.
Okay, when will we go over, if I still feel the same way, over the
I'm always willing to hear that.
motion to dismiss and for the reasons why I gave?
I'm always willing to hear
Okay.
that, but what I can tell you is normally what needs to happen is if you want a different attorney,
Yeah.
you have to hire one.
Yeah.
But he's willing to go over the indictment with you again, so he will do that.
Okay.
All right, thank you.
Thank you, Judge.
You're welcome. You're welcome. Are you already on Cox?
Yes, Your Honor.
All right, can I see the file on Cox, please? All right, so what is the decision on Mr. Cox?
Your Honor, I believe the state and I both had the opportunity to speak to the complaining witness in exchange for complete upfront restitution. She agreed for the case to be dismissed up through a TIC and then to continue on probation. I don't believe there's anything else that you have.
That's it, Your Honor.
Well, on the motions to revoke, we're proceeding on those, correct?
We have agreed to plea on 17 and 19 on these two different motions.
All right.
To continue on 2 years, extend for 3 years.
All right, court is calling 2021 CR 4964, 2018 CR 11550, State versus Michael H. Cox II. That party is announced for the record. State,
Andrew Harris Edelman.
defense.
Austin Nagy for Mr. Cox.
And are you Mr. Cox?
Yes, ma'am.
Are you the same Michael H. Cox II who was placed on deferred adjudication in 2021 CR 4964 for the offense of theft, $30,000 to $150,000 on December 6, 2021 for a period of 4 years? And the same Michael H. Cox II who was placed on deferred adjudication in 2018 CR 11550 for the offense of theft, $2,500 to $30,000 on January 14, 2020 for a period of 3 years. Is that you?
Yes.
State, are you proceeding on the same allegation in each motion?
Yes and no, Your Honor. The substance is the same for each, but they have different numbers.
Right.
So in 2021 CR 4964, on or about the 6th day of February 2024 in Bear County, Texas, the defendant, Michael H. Cox II, did then and there fail to register for or attend a theft program level 2 with the approved agency in violation of condition number 17.
How do you plead to that? True or not true?
State waives the remaining violation allegations, Your Honor.
Any objection?
No, Your Honor.
In 2018 CR 11550, on or about the 6th day of February 2024 in Bear County, Texas, the defendant, Michael H. Cox II, did then and there fail to register for or attend a theft program level 2 with the approved agency in violation of condition number 19.
How do you plead to that? True or not true?
State waives the remaining violation allegations, Your Honor.
Without any objection?
Yes, Your Honor. No objection.
All right. Did you understand by pleading true to violation of condition number 17 and cause number ending in 6-4, court could find you guilty, grant the motion, and sentence you up to 10 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition 17?
Yes, ma'am.
Court will find violation of condition number 17 true. And in cause number 2018 CR 11550, did you understand by pleading true to violation of condition number 19, court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition 19?
Yes.
Court will find violation of condition number 19 true. And it is the court's understanding that the case that he paid restitution on, that was just some case that had been floating
It
out
was
there.
at large, Your Honor.
Okay.
Yeah.
All right. Is there a proposed agreement?
Yes, Your Honor. In each case to extend probation for 24 months with all conditions in effect.
All right. Probation, and the cause number ended in 11550. Is there a restitution amount that's currently due?
Judge. Yes, there is a balance. There is an amount due. He is currently making payments on that.
All right. The court will deny the motion in that cause number. Alter and amend conditions to extend for 2 years. There's an issue with regards. How long are you asking for an extension?
Judge, we're asking for 24 months on each case. And we do realize that this case is already expired.
Mm-hmm. With regards to this case, he can be terminated unsat, and the restitution amount can be transferred to the other case.
I don't have opposition to that. The state does.
If that's what the court mandates.
All right. Any objection from the state?
No, Your Honor.
All right. What is the amount that's due in cause number 2018 CR 11550?
$7,836.
All right. Defense, do you agree that that's the amount due?
That is the amount that I have seen, Your Honor. I do agree that that would be the amount.
And is the complainant Beverly Ahnee, Ahnee?
Yes, Your Honor.
That is correct. Beverly on.
All right. So any objection from either side to the court terminating him unsatisfactorily in that cause number and transferring the restitution amount to this cause number?
No, Your Honor. No objection from the defense.
Not from the state, Your Honor.
All right. Then the court is going to terminate him unsat in that cause number. And in cause number 2021 CR 4964, the court is going to deny the motion to alter and amend conditions to extend for 2 years. And there's to be restitution to Beverly Ahnee in the amount of $7,836. And probation, when do you want him to sign up for this class?
Is that court start
Yes.
by the end of January?
All right, you're to enroll in the theft course by January 30th, 2025. Do you understand?
I believe I have the certificate. I just.
All right, is there anything else from either side?
Yes, Your Honor. If I may.
Yes. You're welcome. All right, you need to make sure you pay this restitution, you understand? And make sure you sign up for that course. Otherwise, another motion to revoke is going to be filed.
Yes, ma'am.
All right, good luck to you.
This one.
Thank you, Your Honor.
You're welcome.
May I be excused, Your Honor?
Yes.
Thank you.
Judge, would like to file on that case.
No, I don't need it. I'm just going to put it in the system.
This judge.
Here you are.
Thank you, ma'am.
You're welcome. And that dismissal was in 008018.
Yes, ma'am.
All right, thank you.